Good morning and welcome to Flash Briefings by Manning Fulton. Today's topic, data privacy for the growing company, is the sixth of Manning Fulton's Flash Briefings, designed to provide you with key legal insights in support of your business objectives and do so in a manner you can quickly digest. My name is Alan Dickinson, the Director of Client Relations here at Manning Fulton, and I'm very glad you can join us. It's my pleasure to introduce my colleagues Chuck Munn and Carly Smith, two exceptional corporate attorneys who will be leading today's session. You will have the opportunity to submit questions this morning by typing your questions into the questions pane of the webinar's control panel, and we encourage you to do so at any time during the presentation. If we are unable to address your questions during the session itself, Mr. Munn or Ms. Smith will contact you directly following the presentation. And with that, I turn it over to Chuck.
Thanks, Alan. Again, and thank you everyone for joining us this morning for this briefing on data privacy. As you guys probably know, data privacy is a very hot topic now in the legal world, and things are changing on a daily basis. And that's, while we're here, we live and breathe this stuff so that you guys don't have to. So again, if you guys have any data privacy questions or want to just talk data privacy, please, don't feel free to contact me or Carly or your Manning Fulton representative, and let's start a conversation, as they say in LinkedIn. We're here to help. So with that, if we're going to have a discussion on data privacy, I guess we need to start with actually talking about what is data privacy. And I will start with the third bullet down there, because you see these terms used interchangeably: data privacy and data protection. You'll see them interchangeably. You can do that. I think there's a little bit of difference in each one of them, and you'll see both of these things within data privacy laws. Data privacy itself really is more of an individual right, and that's what you see a lot of now, especially in Europe. It's an individual's right to control his or her own personal information. For example, my social security number is my number. It identifies me and no one else. So it makes sense that I should have the right to control where that goes and who uses it and how they use it. So you'll see in data privacy laws, there's three basic things that you'll see what the laws focus on. One is this right of privacy and the individual rights that an individual has over their personal information. You'll see that in there. Then you'll also see a couple of things that, again, I think is more around data protection. The laws will focus on the purposes for which companies are collecting and using personal information, which makes sense. You want to make sure that if you have a company out there collecting this data, then they ought to be using it for legitimate reasons. And actually, the CCPA in California uses the term legitimate business purpose. Also, the laws will actually focus on how this personal information is being processed, and processed is a broad term. It means basically anything that you do with personal information: the collection, the use, the storage, how you secure it, and all the way to the end of its life when you delete it. So now that we've talked about actually what data privacy is, and obviously a key component of data privacy is personal information. So what actually is personal information? Here in the US, you've probably recognized this acronym, personally identifiable information. That's a key term that we use here. As a subset of PII is something called sensitive personally identifiable information. Again, personal information really is any information that would allow you to identify an individual. These are just a few examples here, including like names, addresses, email addresses. And down in the sensitive area, these obviously are sensitive for various reasons, for obvious reasons. So security numbers, financial information, your driver's license number, and medical information. All these, if you are touching any of this information in your business, then you most likely will need to comply with some type of data privacy law. The third category down there is obviously non-personal information, and this information does not apply to data privacy regulations. It's really information that's anonymized or aggregated or de-identified, such that if you have a piece of this information, there's no way that you can take it and use it to identify a specific individual. So next, let's talk about, do data privacy laws actually apply to my business? Well, as we've said, it really comes down to whether or not you're processing personal information. Again, processing is anything that you do with it, the collection of it, the use of it, the storage of it. The last statement there is probably the best I have found as to what processing is, and it's pretty much anything that you do with it from the first time you touch it until you get rid of it. So this is an area where you need to focus on. If you actually are processing personal information, then you probably need to look into some type of compliance with data privacy. Next, let's talk about what data privacy laws actually would apply to your business. In the U.S., unfortunately, there's no one single federal data privacy law, sort of like there is in Europe now with the GDPR. We don't have that. There's been talks in Congress about starting discussions about getting a one data privacy law in effect, but right now we're not there. In the U.S. over the years, as data privacy has become more of an issue, it's really been developed more within the federal laws, where they were actually amended or new regulations were issued within the federal laws, and it really built out amongst the different industries, as you see there. All these different industries have their own separate types of regulations around data privacy, and Carly will be discussing some of the key federal statutes here shortly. The states are also getting involved. As I just said, California, this is the most recent one. The CCPA is in effect. California, Nevada, and Maine, they're the main states now that have their actual full-fledged data privacy regulations. Other states are in the process in discussions and trying to enact that. So a lot of that's going to be coming down the pipe. So basically, with all that, which of these laws actually apply to me, and then you get the standard legal answer. It depends, and it varies depending on the type of PII that you're actually collecting and using. Depends on which industries you're actually operating in and which jurisdictions you're in, because all of that will make a difference as to which of these regulations apply to you. At this point, I think I'll turn it over to Carly, and she's going to talk about some key federal data privacy laws.
Thanks, Chuck, and thanks everybody for joining us this morning. So here are just some overview of some laws that you may have heard of in the media or in your business operations. So the Gramm-Leach-Bliley Act applies to financial institutions. So that's banks, mortgage companies, securities firms, financial advisors, or even retail companies that are issuing credit cards. The main tenets of the law require these financial businesses to notify the customers how they process their information and seek consent before they give that information to unaffiliated third parties, and to have a written plan for data security. HIPAA is something you're probably very familiar with if you're in a healthcare related industry. Of course, it's going to cover entities that are healthcare providers, but your business might be affected by it if you are providing different services to a covered entity. For example, if you're billing or providing management or some sort of data analysis. HIPAA has three components. There's a privacy component that talks about how they can collect and disclose and use health information. There's a data security component, and then there's some regulations that deal with how covered entities need to share or limits on their sharing of information with other entities. The Children's Online Privacy Protection Act is aimed at protecting kids under the age of 13. It's going to apply to your business if you are directing your business activities to kids who are under 13 and you're collecting their information as well. The main components of this act are that parents need to have notice that you're collecting information, and they need to give consent before you can collect and use it. A component of this law is actual knowledge that you're collecting information from kids under 13. So example, if a 12-year-old is using their parents' credit card to buy a product on your website and you have no way of knowing that it's the 12-year-old actually using that service or making that purchase, you don't have knowledge. The notable litigation in this space actually wrapped up last year in 2019 with a FTC action against YouTube and Google, because they were tracking through cookies the activity of users who were watching different YouTube channels, including channels that were directed at kids. And YouTube hadn't given the proper disclosures or sought parental consent for users that were probably under the age of 13. And they settled that for over $170 million, so not insignificant. The Telephone Consumer Protection Act and the CAN-SPAM Act applied to how you use emails and phone numbers. It's going to regulate the content and the timing of the messages that you send to your customers via those means, and there's some opt-out and consent requirements as well. Finally, though the FTC is not a privacy regulator, it does enforce consumer protection laws, especially, unfair and deceptive practice laws, laws that prohibit those. And so the FTC has enacted and come against different businesses who do not follow what they've stated their data practices are in their privacy policies, or if they change their privacy policies and practices without giving notice to consumers, or if they don't have security measures for sensitive consumer information. The FTC has also put out some general guidelines and resources to help you if you're just getting started and want to think about privacy in a new way. And then its jurisdiction is really broad. So if you're a business or an individual doing business in the United States, the FTC has authority over you. So the takeaways from these federal laws are, if you're in a specific industry, always check to see what regulations are going to apply to you. Second, the basic components of how you comply with these different laws are pretty similar in that they all require you to understand where you're getting information, how you use it, store it, and disclose it. Then you'll need to be able to process certain consumer requests or consents or requests to opt out, and then have some basic security measures as well. Finally, as you're developing those basic things, it's going to lead you to have a privacy policy and a data security plan. And once you've developed it, you need to stick with it and implement it. Or if your practices change, you need to provide timely updates to your customers about what those changes are. I'll turn it back to Chuck.
Great, thanks, Carly. I'll talk about some of the key state laws. If the technology will, there it goes. So at first, what the states ended up doing, Carly mentioned the FTC and their use of the Unfair and Deceptive Trade Practices Act in order to police some of the bad actors around data privacy. Well, the states kicked in and they all basically wanted to enact their own type of consumer protection statutes, which pretty much mirrored what the FTC had in place regarding unfair and deceptive trade practices. Those all became known as the baby FTC Acts, obviously because they were at the state level. Other places where states have gotten involved really are where there are no federal legislation governing a certain area. These two of the biggest ones are data security laws and data breach laws. Also, data breach laws also can be referred to as data breach notification laws. It's hard to believe, but for purposes of data security, there's not really any federal legislation in place that imposes a minimum level of information security that a company is required to keep with regard to securing and protecting the personal information that it houses. So states basically got involved and they've passed their own laws to set these minimum levels to make sure companies actually have something there to protect personal information that they have. In the data breach section, again, there's no real federal regulations right now that require companies to publicly disclose on data breaches. A lot of that is state driven. And as you've noticed, most recently, you've seen a lot of the bigger data breaches that are out there, and those are driven by the states. One of the biggest legislations that has recently was enacted was the California Consumer Privacy Act. I just want to hit on this real quick in case it does apply to you guys. It really is a very significant piece of state legislation. It's not as stringent as the EU's GDPR, but there is a significant amount of additional disclosure that is required if this act applies to you. And real quickly, in a nutshell, if you're a for-profit business, if you're doing business in California, which would include if you have an online business, so if you have a website and you're marketing to the California residents, and a part of that you're collecting personal information from California residents, and if you meet the threshold of a $25 million in annual gross revenue, that's everywhere, not just California, then this act really would apply to you, and you need to pay attention to it. As I said, the CCPA really increased the amount of additional disclosure that was required. It actually specifically requires a specific notice to the California residents, and I've been helping clients. Basically, they update their privacy policy to make sure there's a link in there for California residents that can go in there and see this actual notice, which a lot of times ends up being longer than the actual privacy policy itself. Here's a laundry list of the additional disclosures. You've got to tell the California residents, what type of personal information that you're processing. You got to tell them why you're processing it. You got to give them the categories of third parties that you're sharing their information with. And if you actually sell California personal information, you got to tell them what the types of categories of information that you're selling. And under the California law, the term sell can be, it's not just if you're getting cash or any type of monetary, cash, but if you are receiving any type of monetary type of value, then this is going to capture you. Clients that basically, if you're using and sharing personal information, for example, in exchange for advertising credits, then obviously that is considered a monetary value under the statute, and then you have to do certain things because you're actually selling that information. One of the more important pieces is that last bullet where it talks about you specifically have to give the individuals the right to access their information. They have the right to delete it, or to get you to actually delete all their information off your systems. And if you're actually selling California residents' personal information, then you have to provide a specific opt-out so they can stop you from selling their information. That includes providing a do not sell info link that will need to be on the front page of your website, right down there where you keep the link to your privacy policy. Let's see here, what's next? Oh, I'll turn it over to Carly, and she's going to give you hopefully some real world examples through this e-commerce hypothetical company here.
Yeah, thanks. I wanted to give you an example because a lot of what we've talked about so far is pretty abstract. So here's a fake company that has pretty standard or basic business practices. We wanted to show you how data privacy concerns will be implicated by their typical business practices. So it's a t-shirt retailer or a clothing retailer with an emphasis on t-shirts. It has a couple of retail locations as well as an e-commerce site. So the first point is just how much personal information this company actually might have. And they're going to get that information from customers who create accounts on their website, or if they're just collecting, emails or phone numbers for different promotional purposes. They might be getting financial information because they're accepting credit cards, both in the store and online. And a lot of companies these days have mobile applications, and that can give you a lot of different types of data depending on what developer and applications you choose. So perhaps you have a site in there where you can track where the location of the customer is so they can find the nearest store to them. Well, that's another bit of information that you could have about them. And even though a lot of data privacy is focused outwardly on customer information, a lot of it applies to the information you have about your employees as well. And you need to take special safeguards to protect that information and follow other obligations. Second point is that marketing is a common place where you're going to get information or disclose it. So if you're using social media marketing, there's often an exchange of information associated with that. And then another common practice is using different tracking pixels or cookies or mechanisms through your email or your website so you can deliver targeted advertisements or track the performance of certain promotions and other communications. Next part is that vendors also are going to receive information. No business is entirely self-sufficient. You're going to have different vendors to supply different business services, and that's going to require that you give them certain customer information. So maybe you have Google Analytics to track your SEO and your search marketing. You have a CRM program that's going to store customer information and leads and promotions. Another vendor for this t-shirt company is actually going to deliver the products to customers. And then maybe this company has another vendor that's an authorized reseller of its products, and it's going to send data back about its purchasers and customers back to the original retailer. Finally, as this business is looking to expand and grow, it might implicate different privacy laws. So perhaps they have a pop culture t-shirt that's been generating a lot of interest with kids and teens, and they want to capitalize on that. Well, maybe there's some COPPA concerns, or they want to go into California. It's a growing market, but doing so might trigger compliance with the CCPA. The point is there's a lot of different basic business practices that you have involving a lot of different components of your business. The data privacy is going to touch.
Okay, great. Since we've really been talking about compliance, we thought, at least we ought to talk about some of the risks and benefits. The risks of non-compliance, obviously, which is I'm going to talk about now, and then Carly will talk about some of the other benefits of actually complying. But with regard to non-compliance, these are probably pretty obvious to you guys. If you're not complying with these laws, the federal regulators are going to come down on you. There's lots of potential penalties and fines that you can get hit with. Obviously, here's some examples under CAN-SPAM, which obviously these are all those commercial emails. So if you're sending out spam emails from a marketing standpoint, there's a lot of, a list of specific things that have to happen in those emails, including letting those guys know that it's an advertisement and providing them some type of opt-out or unsubscribe on that email. And there, you can see the violation up to $43,000, per violation, which can rack up if you're sending out multiple emails. Under COPPA, again, that's a $40,000 per violation fine. So you really want to be paying attention to that if you're actually out there marketing to children online. The CCPA is actually interesting. Their fines right now are only up to $7,500 per violation, which I think is going to change pretty quickly. And actually, 75 is if you're intentionally not complying with the CCPA, and hopefully people aren't doing that, but that's if they can't get up to speed quickly, it's not much of a fine compared to other regulations. And I just threw the GDPR in here just because the fines are so significant. If you actually are doing business in Europe, you really need to start paying attention to the GDPR if you're not, because obviously those are the fines, 20 million euros or 4% of your annual revenues, whichever is higher. And there are a number of different, I guess, enforcement actions that are out there in some large numbers. I think British Airlines just got fined 205 million, and there's others out there. So if you're doing business in Europe, you need to pay attention to that. Also, some of these regulations provide an individual private right of action, which basically means the individual, him or herself, can actually sue you for sending them an inappropriate email, for example. So you want to pay attention to that because that can be just a big hassle. Some other risks are, or one is the data privacy. A data breach issue, where if you're not complying with data privacy laws, then you're probably not paying much attention to the security of your personal information online, and then you can have a data breach, and that gets expensive when you have to follow the state data breach notification laws, and trying to clean that up can be quite expensive. And also, obviously, there's going to be reputational cost. If people see, or if potential customers see that you've got enforcement actions against you, or you've got data breaches, then obviously that can create some problems with regard to whether they want to actually do business with you, including providing their information to you guys. I will turn it over to Carly. She's going to talk about some of the benefits of compliance.
All right, the first benefit is that you have the opportunity to earn the consumer's trust. Here's some data I found from the Pew Research Center. If it comes up here, that shows that a lot of Americans are concerned about data privacy. So they're concerned about what companies are doing with their information once they have it. They're concerned about, sorry for the slide issue here. They're concerned. They're concerned about how little control they have, and they're concerned that it's going to be disclosed in ways that they wouldn't have hoped for. So the way that you can respond to that is by being really forthright and answering those consumer questions. So your privacy policy is a perfect way to do that. You're explaining how you get their information, what you do with it, and why you're doing what you do. You also give them some control over the data privacy because you give them opt-out options, or if you want to go further than that, perhaps you give them some of the rights that states are increasingly asking you to do so, like requiring them to access or know how much you have about them or delete it if they make that request. If you're having that communication and notifying them about updates, hopefully you'll be able to have a huge advantage over your competitors who aren't providing that information and showing that trust and respect for the consumer and being a good steward of their information. The second point is that you keep the consumer's trust by not having a data breach. Data breaches are going to affect significant companies, large and sophisticated companies like Marriott, Experian, Facebook, but it's increasingly affecting smaller companies too. So for example, the Bank of America study I found showed that since 2017, the number of small businesses who pay over $50,000 to resolve issues related to data breaches went up 10% to 41% overall. And then consumers are increasingly saying they're not going to return to small businesses that have a data breach, and up to 30% said that they wouldn't return in 2019. So the data breach is an immediate way to harm your consumers' trust and the reputation of your brand. So by having early compliance efforts, you're going to avoid that. Third, as you're doing all this analysis to figure out how you use data and what you can do better, you're going to identify growth opportunities. You might become more efficient because you learn what data you have and the flow of the data, and how you can maximize its use and purposes and get a better return on your investment. You might decide that you have more information that you really need, and so by eliminating it, you can cut down on storage and security costs. It's an opportunity to explore new technologies that can streamline those processes. And then as you're just developing better controls and security, you're going to make your company more attractive to prospective investors or future purchasers. So all those things are going to give you a competitive edge.
Great. So I know we've been harping on compliance, so let's take a look at what you guys, if you want to comply, where do you get started? And I know we're running short on time, so I'll quickly run through this slide here. Basically, what you have to do is you've got to assess whether or not you're actually processing personal information. You need to get in there and you need to do a data inventory. You need to identify what types of, do you have personal information that you're processing by your company? Classify that data. Is it truly personal information? Map out your data flow. Find out where all your data is going. Where are you getting the personal information from? Who are you sharing it with? And then if you are actually processing personal information, then you need to set up some data accountability. You need to have an individual or a group, depending on the amount of information and processes that you have in place, so that someone's paying attention to this on a daily basis. Also, obviously, the first thing that you have to do, and it's required by law, is you need a privacy policy. You need it in place. You need it implemented, and most importantly, you need to comply by it. So, because what happens, and what we'll talk about now is I'm going to turn it back over to Carly, and she's going to talk about maybe if you do happen to have a data breach, with hopefully you don't, but odds are that at some point you might, that you really need to be prepared for that.
The first step is always having a great plan so that you can respond to small concerns or frustrations, as well as a full-on crisis. It's going to make all of those things more manageable. So the first step in that plan is defining who's going to be involved in responding to a data breach. Define your team. And that team needs to include at least one primary person who's going to be responsible for coordinating everything and escalating it as it's necessary. Second, figure out where you're going to determine that you're going to have these data breaches. You might have automatic detection with your technology. It might come from employees or your IT team, and also might just come from your consumers or your vendors. Plan how you're going to respond to these various concerns and escalate them appropriately. Figure out when you need to talk to legal counsel, leadership in your company, and eventually to the consumer. Develop a strategy of how to contain and recover information. I'm not an IT specialist, but if you can find ways to make those systems offline or segregate them if they've been compromised, how you can recover breached data as quickly as possible and determine what data was even breached in the first place are going to be important. Next up is you're going to want to document everything that you can about the data breach itself and your response plan. That's an important risk management step. And you're going to be communicating about this. When do your employees need to know? When does the leadership need to know? When does local counsel or a public relations firm need to know? And then eventually you might, if you've had an actual compromise of the information, you might be required to notify your consumers. That's often pursuant to different state laws. The timeline for that can be pretty quick. So you want to have a good idea of what you need to do beforehand so that you can respond quickly. They need to train people on this plan. It's no good if they can't implement it. And then after you've had a drill or an actual incident, take time to reevaluate how this plan worked and try to improve it.
Great. And one of the last topics I'll quickly go through here, since we're running short on time again, it's pretty important, and it relates to how data privacy affects your service provider relationships. Everybody's got different service providers or vendors out there that are helping them. So it's very important that you understand, what type of security procedures or processes that your vendors and your service providers have, because you're giving them your personal information to use. Do you know what they're doing with it? You really need to go in there, and one of the first steps is to do some type of service provider assessment. Go in there and see what kind of data protection they have in place. Do they have good security procedures in place to protect your data? An important thing to do is make sure you have contracts in place with these service providers, and you outline exactly, here's the information I'm going to give you, here's exactly what you're going to do with it. You're not doing anything else with that personal information. You're not sharing it with anybody. You're not selling it to anybody. And you also have a minimum level of security practices and procedures that is in the contract that you hold your service provider accountable for, so at least you have some comfort that there will be some protection that you're comfortable with over the personal information you're sharing with them. And you really need to have a really solid indemnification clause in there, because if your vendor or your service provider happens to have a data breach, obviously it's your personal data, because and that breach is going to be on you, and you're going to be responsible for cleaning it up. So you want to make sure that you've got some protections in that contract to make sure that you can recoup those costs back from your service provider that caused that breach. I know that was a lot of information in 30 minutes. Hopefully some of it was informative to you guys. We appreciate your time today, and if you have any questions or you want to talk about data privacy, please reach out to one of us, and we'll be happy to have you engage in that conversation. Hope you guys have the rest, good rest of your day, and that's the end of the program.